What it do? What it do? What it do, firm? What it do, firm? All right. I thought I had more in here than just five, but I got my favorite five. Hey, Lisa Williams. What up, boo? Bill, what's going on? Nona, hello. I got 8. Still depressing. Still depressing. How about if I just do it like this then? How about if I do it like this? How about if I do it like this? What I want to do, got 12. Still kind of depressing. So what I'm going to do is I'm going to play this commercial real quick. Then I'm going to go off and come back on.
I don't tell God about my problems. I tell my problems about my God. I love my fans. I thank y'all for supporting Kels. Continue to if you want to. To all of the haters, I love you because you inspire me. All right, one.
Out of the belly of a mother, born into the belly of the beast. No college, but street knowledge. A child often haunted by the thought of a ghost father. But yet, the man in me rises higher and higher, fueled by my relentless desires to climb the hill and see the mountains, and still continue to go even higher. Can't stop now. Must endure into the finish. I'll fly until the sky becomes my ground, and the universe becomes my limit. The earth becomes my turf, and every man, woman, child becomes witness to my walk. my story, my journey, and my...
Hold on, y'all. Let me see what's going on. Hold on. Hold on, y'all. Let's see what's going on. I'm going to take it back.
I don't tell God about my problems. I tell my problems about my God. I love my fans. I thank y'all for supporting Kels. Continue to if you want to. To all of the haters, I love you because you inspire me. All right, one.
Out of the belly of a mother, born into the belly of the beast. No college, but street knowledge. A child often haunted by the thought of a ghost father. But yet, the man in me rises higher and higher, fueled by my relentless desires to climb the hill and see the mountains, and still continue to go even higher. Can't stop now, must endure into the finish. I'll fly until the sky becomes my ground, and the universe becomes my limit. The earth becomes my turf, and every man, woman, child becomes witness to my walk, my story, my journey, and my...
Greed, lies, and an untruth TV series.
When a woman loves.
September 28th at 4 p.m. in downtown Brooklyn, New York at the Fort Greene Park. It's the March for Justice and Equal Rights. It's the March for R. Kelly.
And I'm calling on and I need somebody out there wanting to embrace it.
We are asking Brooklyn, Queens, Bronx, and the whole tri-state to come show your support and march with us for justice. It could be you or your family member next. September 28th at 4 p.m. The March for Justice for R. Kelly at Fort Greene Park.
All right. The March for R. Kelly, the March for Justice at Fort Greene Park. How many of y'all gonna meet me there? How many of y'all gonna meet me there? That's what I want to know. How many of y'all gonna meet me there? But I want to say, what up, chat? What's going on, Fern? How y'all doing today? A little tired, but hey, let's get it in. Let's get it in today. Trying to find this R. Kelly music real quick. Just getting it from work. Had a good time. Got to go back to work when I finish this joint, but hey. It'll be okay. So, I'm going to go ahead with it first. Go ahead with it first.
Yeah. Oh, yeah. Oh, yeah. Oh, yeah. Oh, yeah. Oh, I hear them tell me that they love the music. And even how some of the songs has gotten them through. Yeah. And through the years I've heard nothing but keep doing it. They even say to me, I got kids 'cause of you. Well, here's to all the 90s babies, single mothers or daddy's maybes, whether rich or whether poor. This is who this song is for. 'Cause I know that you are born to my music. Oh, whoever you are born to my music. Oh, generations, population, you are born to my music. And it's such a blessing, thank you, heaven. Born to my music. Oh, I've heard them tell me, boy, you are gifted. And some has even said your music's uplifting. I heard people say that come what may, you are the king. And it feels so good to hear them say your music has touched me. Here's to all the 90s babies, single mothers or daddies maybes, whether rich or rather poor. This is who this song is for. 'Cause I know that you are born to my music. Oh, whoever you are born to my music. Oh, generations, population, you are born to my music. And it's such a blessing, thank you, heaven. Born to my music. People tell me thank you for the memories you've given me. And I just say it's my pleasure, yeah.
Share with your friends. Let them know they don't want to miss this.
To all of my loyal friends, I thank y'all for the dance. I feel so blessed to be a part of all of y'all memories. So thankful to be a part of touching the whole world's heart. At least those of you who are born to my music. And I'm so grateful to my music to know that so many was born to my music. It puts some joy down in my soul to know that you are born to my music. You are born to my music. You are born to my music. Born to my music. Yes, you are born to my music. I thank God for my music, born to my music, and it feels good to know that you were born to my music. Born to my music.
All right. Born to my music. So we're going to talk about this motion or this rebuttal. But before I do that, I want to say what up to everybody in the chat. All of my friends, all of the firm, AD Music, what's going on? All right, we got some folks in here. The guy 45 is not what we're used to, but hey, it is what it is. Kiva, Nakia, Zay, Lisa, Junior, Empado, Lene, Miss Hot Pink, and everybody else in the chat. Everybody in the firm. We got the United States of America versus Robert Sylvester Kelly, a.k.a. R. Kelly, in Chicago. This is the government's response to defendant Kelly's motion for disclosure and protective order. It says the United States of America, through its attorney, John R. Losh, Jr., United States Attorney for the Northern District of Illinois, hereby responds to defendant Robert Kelly's motion to require the disclosure of grand jury subpoenas, production of all grand jury materials, and for a protective order. Docket number 133. In the motion, Kelly alleges that the government acted improperly in issuing grand jury subpoenas that resulted in the collection of bank records of Kelly's current and former counsel, specifically attorney number A, and the law firm A. ID for the reasons identified below. The government the government respectfully requests that the court deny the motion. Introduction. I. The superseding indictment alleges that over the course of 20 years, Kelly paid money to others, including minor one, which we all know that's Geronda. Minors one, that's not Geronda, I'm sorry. That's Rashona Lanford, including minor one, minor one's family, Daryl McDavid, and individuals B, C, and D, in exchange for them to lie about Kelly's sexual abuse of minors or their efforts to collect and conceal child pornography involving Kelly's abuse of minors. Kelly made many of the payments through an attorney during the course of its investigation. The government issued subpoenas to banks for accounts from which these payments were made and for accounts that received these payments, collecting evidence proving who was paid and that Kelly or his business were the source of the payments. In addition, in the course of its investigation, the government identified a bank account that Kelly appeared to control through a nominee third party, in part because of Kelly's history of bribing victims and witnesses. Excuse me, y'all. The government investigated this account to determine whether Kelly controlled it or whether he was using a nominee to conceal its activity. To that end, the government issued bank subpoenas relating to various payees from the third-party account whose identities were not known to the government. When the banks produced records in response to the subpoenas, the government learned that two of those payees were attorneys, including attorney A. The government produced to all counsel the records that is received. I don't know why I'm sleepy, y'all. Y'all gotta forgive me. The records that it received in response to those subpoenas pursuant to the strict terms of the protective order, in this case, docket number 53. Kelly now asserts that in issuing these subpoenas, the government went on an unreasonable, intimidating, and harassing fishing expedition relating to Kelly's current and former counsel, specifically attorney A and law firm A. Docket number 133 at 2. Not so, as explained below. The government had legitimate law enforcement reasons for subpoenaing the bank records at issue. The bank records proved that defendant, the other was attorney B. The bank records proved that defendant blank, the other was attorney B, right? Who is not mentioned in Kelly's motion. The indictment does not allege that attorney A, law firm A, or attorney at law firm A engaged in wrongdoing. So if the indictment don't allege that the attorney or law firm A or any attorney at law firm A was engaged in wrongdoing, why would you subpoena the records? That's what I want to know. If the government ain't trying to say that attorney A, law firm A, or any attorney at law firm A was engaged in wrongdoing, then why do you need to subpoena their records? Then it says, R. Kelly paid $125,000 to individual B for recovering and returning videotapes showing Kelly sexually abused a minor. These records also help prove that defendant controls a nominee bank account that received at least $1.2 million last year, despite claiming to this court that he has no money. This account was established in early 2019, shortly after Kelly was charged with sexual exploitation crimes and the Circuit Court of Cook County by directing substantial income to a nominee bank account. It appears Kelly was attempting to avoid financial consequences associated with the pending criminal charges in this and other cases, including fines and victim restitution. Moreover, given Kelly's past conduct, there is a risk he would use these funds to continue his pattern of paying off witnesses and victims to lie or remain silent about his crimes. All of these facts made it reasonable to subpoena records related to the counts at issue. Wow. So now, not only are they openly saying that R. Kelly is lying, but they're calling him a liar too. That's weird. And then it says, hold on, y'all. Then it says, lacking standing to quash the subpoenas at issue, and because such a motion would be moot at this stage anyway, Kelly instead requests that this court order the government to disclose all grand jury subpoenas and materials not previously disclosed. The requested relief is not appropriate. Out of an abundance of caution, the government already sought and received from counsel for Mr. McDavid and Brown the return of records related to Attorney A. The government agrees to do so the same for bank records related to law firm A. It has already asked for the return of those records from all counsel. Will destroy copies of non-relevant materials included in that production, and will reproduce to counsel only those records it intends to use at trial. It says will destroy copies of non-relevant materials included in that production. So if there was a sex tape involving R. Kelly, I thought y'all needed that. Why y'all talking about why y'all talking about destroying it? And then you said, and will produce to counsel only those records it intends to use at trial. These reasonable measures are sufficient to address counsel's concerns. Accordingly, Kelly's motion should be denied. Then it says part 2. The government reasonably subpoenaed records related to payments to individual B. The Supreme Court has long recognized that the grand jury's investigative power must be broad of its public responsibility and adequately to be discharged. Hold on, y'all. Yes, sir. That's what I need right there. For some reason, I feel sluggish. Okay, I'm back. And it says, power must be broad of its public responsibility is adequately to be discharged. Then they have the case law right here. Then it said, indeed, a grand jury investigation is not fully carried out until every available clue has been run down and all witnesses examined in every proper way to find if a crime has been committed. Then you have case laws. And it says, accordingly, the grand jury may compel the production of evidence or the testimony of witnesses as it considers appropriate, so long as compliance with the subpoena would not be unreasonable or oppressive, which, unlike a trial subpoena, need not be tailored to evidence that would be relevant and admissible to trial. Then it's got R enters ink, whatever that is. Then it says, in the grand jury context, the decision as to what offense will be charged is routinely not made until after grand jury has concluded its investigation. One simply cannot know in advance whether information sought during the investigation will be relevant and admissible in a prosecution for a particular offense. Then it says, consistent with this authority, the government used grand jury subpoenas to investigate payments made by and on behalf of Kelly, to pay off witnesses, and to compensate persons for their efforts to conceal evidence of Kelly's child exploitation. Wow. And then it says, the government's investigation revealed that some payments were made by Kelly through attorneys to settle lawsuits filed by individuals who threatened to release information regarding Kelly's child exploitation. Then it says, including lawsuits filed by individual B and co-defendant McDavid. Specifically, as the superseding indictment alleges, Kelly made multiple payments to individual B. Between approximately 2001 and approximately 2009, Kelly, McDavid, individual A, and others caused individual B to be paid hundreds of thousands of dollars for obtaining and returning multiple videos that they knew depicted Kelly engaged in sexual contact and sexual acts with minors. Wow. So basically what I'm getting out of that is they taking Daryl McDavid's story or whatever he told them against R. Kelly and they running with it. That's what I'm getting. Superseding indictment at 6A, at least one of these payments to individual B occurred on or about June the 30th, 2009. When on or about June 30th, 2009, Kelly and McDavid caused a wire payment to be made from a base production, LTD, bank account to pay individual B to settle a lawsuit that individual B had filed for payment for recovering and returning videotapes that depicted Kelly engaged in sexual contact and sexual acts with a minor. So what happens when they find out R. Kelly that didn't do none of this? And what I'm looking at, it seemed like Daryl McDavid went down there and said whatever he had to say to get free or to not do a day in jail. Okay. The government's investigation revealed that this June 30th, 2009, payment was for $125,000 and was facilitated through Kelly's former attorney at law firm A. One of the grand jury subpoenas at issue requested records for the relevant time frame associated with the bank account held by law firm A used to make the $125,000 payment, as well as for the bank records for the payments to individual B from individual B's attorney. These records, together with the bank records of Kelly's business, Base Productions, revealed that Base Productions wired $125,000 to law firm A, which then wired $125,000 to individual B's attorney, who ultimately made two payments to individual B. Wow. Contrary to Kelly claims, this was not a fishing expedition. The grand jury was investigating the source of payments made to individual B, which were a part of Kelly's obstruction of justice, after it was determined that at least one of these payments were made via an account held by law firm A. It was reasonable for a grand jury subpoena to be issued to a bank seeking records for that account. Bank records received in response to the subpoena have been produced by the government only to counsel of record pursuant to a strict protective order that restricts defense counsel from further dissemination. This is wild. Kelly cites Section 913.410 of the U.S. Attorney's Manual, now known as the Justice Manual, for the alleged proposition that the government should have provided notice of the subpoena to law firm A and attorney A, discussed below. The Justice Manual provides no such thing. The section cited by Kelly refers to subpoenas sent to an attorney, not to a bank. Indeed, the action expressly excludes a subpoena to a bank for records of an attorney trust account, because trust accounts tend to hold the pool funds of numerous clients, and records related to such accounts ordinarily do not relate to individual clients and do not contain or reflect privilege or confidential attorney-client communications. I'm going to stop right there. So right now, everybody that called Angel Cruel and the government talking about $1 for the king, I want to thank y'all because y'all really hammered Robert. And once again, it's right here. It says, and records related to such accounts ordinarily do not relate to individual clients and do not contain or reflect privilege or confidential attorney-client communications. I'm going to go back up. It says the section cited by Kelly refers to subpoenas sent to an attorney, not to a bank. Indeed. Oh, not to a bank. Indeed, the section expressly excludes a subpoena to a bank for the records of an attorney's trust account. R. Kelly, $1 for the King, the R. Kelly Defense Fund, is being held in Doug Anton's trust account. And they only subpoenaed Doug Anton's trust account, not nobody else's. Because trust accounts tend to hold the pooled funds of numerous clients, and records related to such accounts ordinarily do not relate to individual clients and do not contain or reflect privilege or confidential attorney-client communications. So everybody that called them Angel Cruel to talk about the defense fund, it just made it to the rebuttal. This don't make no sense. Kelly also incorrectly contends that the bank records may be protected by the attorney-client privilege. Simply put, in order for the attorney-client privilege to attach, the communication in question must be made, 1, in confidence, 2, in connection with the provision of legal services, 3, to an attorney, and 4, in the context of an attorney-client relationship. Then they have a case law. And it says here the bank records sought by the grand jury were transaction records held by third-party financial institutions. Thus, the records are not confidential communications between an attorney and client, and they are not cloaked in attorney-client privilege. There's a bunch of case laws. And it says, in short, the issuance of the subpoena was not an abuse of the grand jury's powers, and there is no cause to grant the broad relief Kelly now requests. Kelly demands that this court permit his attorneys to review all grand jury subpoenas, not just the subpoenas allegedly used in error. The materials produced to the government and in response to all grand jury subpoenas. While some grand jury material has been disclosed to the defense in the ordinary course of discovery, the defense is requesting all grand jury materials amazed in the court in the course of the investigation, even if the government otherwise would not be required to disclose. This is crazy. There's a bunch of case laws. Those materials in discovery, such relief will be extraordinary and is unnecessary under the circumstances. A defendant seeking grand jury materials bears the burden of making a strong showing of particularized need for grand jury materials. Before disclosure will be allowed, United States versus Cells Inc. I think that's it. United States versus Cells Inc. Because grand jury proceedings are secret and their disclosure limited by federal rules of criminal procedure, the party seeking grand jury material under Rule 6E must show that the material they seek is indeed to avoid a possible injustice of another judicial system. This is sad. Proceeding that the need for disclosure is greater than the need for continued secrecy, and that the request is structured to cover only material so needed. Then I have another case law. And it says Kelly has not made that showing. As discussed above, the subpoena for the account held by law firm A is reasonably issued in the course of the grand jury's investigation. And to the extent the subpoena resulted in a production of records unrelated to the $125,000 payment from the Kelly to individual B. The government has asked counsel to return the records, and the government will destroy them, as well as all copies in the government's possession. At trial, the government will seek a stipulation related to the $125,000 payment. To the extent a stipulation is not possible, if the government will seek only the introduced records from law firm A bank accounts that are related to the $125,000 payment to individual B, describe love, and the government does not intend to publicly disclose the identity of law firm A. The fact that the subpoena was a proper use of the grand jury, the government's the government's limited use of bank records related to law firm A, together with its efforts to ensure that unrelated bank records are returned and destroyed, moots the need for further remedy. So what y'all think so far? Do y'all understand what's going on so far? That's what I want to know. Do y'all understand what's going on so far? Hey, how you doing? Do y'all understand what's going on right now in the chat? Yes or no? You a little lost? Just join. Okay. Then it says, together with his efforts to ensure the bank unrelated bank records are returned and destroyed, moots the end of the day hurt forever. So this right here is just a government subpoena. Another government subpoena. Another government subpoena. Some paperwork. And then it go here. I won't read this. Conclusion. The bank subpoenas here were issued for legitimate law enforcement reasons. In the course of the broad investigation to Kelly's acts of instruction, many have a potential use of a nominee bank account to conceal weapons and not to harass R. Kelly. Kelly's wild accusations and inaccurate speculation as to the government motives are unfolded. And in my heart will not stop the broad disclosure of all grand jury subpoenas and materials not otherwise discoverable in the criminal case to the defense. In addition, the government's transparency, producing the records and efforts to limit the use of dissemination of unrelated. And let's go right there. So, with that being said, hey, Marshall. With that being said, it says the government will do the same with respect to Attorney B, despite Kelly not complaining about Attorney's B records. Records moots the need for any additional remedy. Kelly's motivation, therefore, should be denied. Kelly's motion, therefore, should be denied. Wow. They really hate Robert. And Robert is the one that's the real victim. Can y'all hear me now? Okay. So with that being said, Robert is the victim, but the government acting like he's not, and they're not letting him out. If they have anything to do with it, that's all they said. But also, when I read into that, it simply says that there might not even be a Chicago trial because people don't know what they want. You feel me? So, because people don't know what they want, they might take pieces of it and run with it. I feel you, Lisa. I totally understand. I hate he got to go through it too. It's too much. Hold on. You say Randa Baby. I'm hearing Randa Baby. If Randa in the chat, hello. So that's pretty much all that I'm going to talk about today. And I'll probably talk about this tomorrow and the next day because this don't really make sense. So y'all get some good night's sleep. I've been on for an hour. Probably not quite an hour. And be back here tomorrow. We'll be here all day tomorrow. All right. Thank you so much. Bye-bye.